You're so organized.
Thank you so much for joining us. I am very pleased today to be able to have you engage with our very distinguished panelists in a discussion about data and sovereignty. I'm going to, and this is a very international panel, I must say. Not only do we have U.S. experts, we have representatives from Australia, the UK, and Israel. So I'm going to introduce our moderator, and then she's going to take over and introduce our panelists, and then get right into things. Jennifer Daskell, who is right there on the end, next to the gentleman at the very end, is a professor and faculty director of the Tech Law and Security Program at American University College of Law, where she teaches and writes in the field of cyber, national security, criminal, and constitutional law. And if I can just take introduction privilege and really thank Jen and also Gary Korn, who will be introduced soon, but who were instrumental in not only conceptualizing this panel, but using their very good names to invite a number of distinguished U.S. and international panelists. So with that, Jen, I will turn it over to you.
Great. Well, thank you, Stephanie. Thanks for the invitation to do this, and thanks to all of you for being here. We are going to have what I hope is an interactive and exciting and stimulating discussion about international law, cyberspace, the range of operations that involve cross-border actions, and what that means for both the future of international and also domestic law. I'm going to do really brief introductions. I'm going to do something slightly non-traditional and actually have the panelists spend a minute talking about where they sit and where they come from. I've seen that done a few times, and I find it more interesting than just hearing people listen to me. So I'm going to do that by going down the row. I'm going to start with Doug Wilson, who is currently the legal director with responsibility for legal affairs and international relations across GCHQ, and I'll let him introduce himself.
Thank you, and it's a pleasure to be here this morning. I'm from GCHQ. We are one of the UK's 3 intelligence agencies. We conduct espionage, we cause effects, and we safeguard cybersecurity. So we spy and we hack, and we try to stop others doing the same to us. GCHQ has been around for 100 years now. It's got its history stemming back to the First World War, some notable achievements in the Second World War and the Cold War. But our sort of current mantra internally is we're 100 years old, but our time is now. And that's because of the nature of society, its technological dependency, and because we are now responsible for the UK's cyber security. Within GCHQ, I'm, as you said, the head lawyer. I'm the head diplomat. We take our legal responsibilities really seriously, both as a matter of domestic law and as a matter of international law. I'm an international lawyer by background. I'm also responsible for our international relations. We rely very much on our people, and they use technology and tradecraft to do our business, but we are also dependent on our partnerships, and that's a big part of my day-to-day role. Pleasure to be here. Thank you.
And to his left is Gary Korn, and I have the great privilege of working with Gary. He joined American University, where I am. We've started a new tech law and security program, and Gary's joined as our program director. So it's a huge honor. He's recently, as I'm sure he will explain, he has recently left U.S. Cyber Command and a long and incredibly impressive career in the military.
Thanks. Good morning. I've been on since 1 October, and great program that we're putting together at American University, and just honored and lucky to have been offered the opportunity to work with Jen on building this program. I officially retired 1 November. I left in midsummer from my position at Cyber Command, where I was the staff judge advocate, the sort of general counsel for the last 5 years, and on active duty for 27 years before that in a variety of different positions, to include as a deputy counsel to the chairman of the Joint Chiefs, on the Army staff in Afghanistan and a number of other places, And so that's what I've been doing. And obviously these issues, certainly for the last 5 years, have been near and dear to my everyday practice. So I've had to think about them quite a bit. But
To his left is Chantel Peterson, who's the Counsel for Operations and Security Law in the Australian Department of Defense. And she, I think, wins the honor for traveling the farthest amongst a panel of people who traveled pretty far to get here. So thank you for joining us.
Thank you for having me. I really appreciate it. So within my role, I sit in a military team reporting to the Director General of the ADF Legal Services, so the head of the Australian military lawyers. And in providing advice, I support Defence's security and intelligence activities, so our defence intelligence agencies, in undertaking security and intelligence work. And in reporting directly to the head of our military legal services, we sit at the strategic level, so where there are legal issues that directly impact the range of defence operations. And then obviously our military lawyers are embedded down to the unit level to provide advice on more tactical issues.
Thank you. And to her left, to my right, is Ona Hathaway, who is a professor of law at Yale University, author of many, many articles and books, and really an impressive scholar. And thank you so much for joining us.
Thanks so much for having me here. As Jen rightly said, I teach international law, national security law, foreign relations law, and cyber law at Yale Law School, where I've taught for over a decade. One of the areas that I've recently taught a great deal about is cyber and trying to think across disciplinary boundaries and thinking about cyber law, policy, and technology, how to integrate sort of deeper understanding of how things actually work in the real world with the kind of academic understanding and legal understanding of how to regulate it. I have run for the last 4 years a workshop called the Yale Cyber Leadership Forum, where we try to bring together people from business, people from government, people from practice, and a few academics to think about these issues together. Particularly the goal there is to bring in the private sector, because solving these problems really is impossible without bringing them on board and understanding how they think about these problems. I served for a very short period of time as a special counsel to the General Counsel at Department of Defense. I took leave from my position at Yale to do that in 2014, 2015, and one of the areas I worked on was cyber, so I've also had a brief glimpse into this from the more practical side.
He comes from Israel's Ministry of Justice, where he's the Director of International Cybersecurity and IT Law, and has been also incredibly generous with me personally, providing comments, super helpful comments on some work that I've been doing, so thank you.
Thank you, it's an honor to be here. I work at the Office of the Deputy Attorney General for International Law. We advise all government departments and agencies on a variety of questions of international law, so things like treaty interpretation, customary law, sovereignty, extraterritorial jurisdiction, privileges and immunities. My involvement specifically is in topics that are at the intersection of international law and technology in the civilian sphere. So I don't deal with a lot of armed conflict stuff. And what I hope, and also I do a little bit of AI stuff, which is getting like an emerging international law component. So mainly cybersecurity, cybercrime, a bit of AI. And what I hope to contribute to the discussion today is specifically that non-LOAC perspective. So from my experience with respect to amendments to Israel's domestic law regarding law enforcement access to data on the cloud, and also the drafting of Israel's cybersecurity law.
Great. So just to give you a sense of what we're going to do, all the panelists are going to kind of set the stage with some opening comments. We're going to start with Gary to kind of provide a framework for thinking about some of these issues. We're going to hear from the government representatives and from Ona as well to offer an international law perspective and talk about some of the challenges. We're going to have a bit of a discussion up here, and then we will open it up at the end for questions from all of you. So I'm going to turn it over to Gary to begin.
Thanks. I think for me, and especially in the time at Cyber Command, there are existing legal frameworks, and we'll hash all that out, both domestically and internationally. lots of questions about, of course, how those frameworks apply. Are they adequate to the task? Do they need to be updated, amended, et cetera? But the start point as a practicing attorney is applying the existing law to facts. And facts are hard in this space. And precision matters. And what I often find is we sort of lump terms together generically. So this panel is interesting. Data, sovereignty, even the notion of data. We'll see how this kind of fleshes out. I think really interesting that not all data is the same. Not all data has the same implications or values behind it. And data that represents a person's intellectual property and thoughts is sort of very different than some of the data that reflects the protocol operations within the internet and how operating systems are functioning, et cetera, et cetera. But we don't oftentimes distinguish that out when we're thinking about operations, right? And then outside network operations, which is when the legal issues really start to ramp up. What you do inside of your own networks can present challenges, but generally consent goes a long way to vitiating most legal issues, and you own your networks and you condition access to your own networks on consent to various monitoring. But outside of your networks, it gets a lot more difficult. And what type of operations are you talking about? I mean, there's lots of different things you can do in and through cyberspace to generate effect or consequence. Most things today, most machines, systems that we rely on have some computational component driving them. We've got some Air Force folks in the room. People no longer refer to fighter aircraft as aircraft. They talk about them as flying computers with someone sitting in the cockpit, right? So you can potentially impact the computational system in order to have an impact or an effect on how the system that depends on it works. So in your broad Internet of Things world and your toaster is linked to the internet and maybe you can muck with somebody's toaster settings and you're going to have them burn the toast all the time. Being a little facetious, but when you talk about SCADA systems and critical infrastructure, so that's one means by which you can manipulate systems to generate some effect or consequence. That's different, in my mind, than operations directed against the information that is contained on computers and networks, where the availability, integrity, and reliability of that information can be critical. And that can be manipulated. That can be sort of the object of attack in the loose term, not in the legal term of attack in the law of armed conflict, right? But so if you think about in a military setting, for example, if you have a commander that's looking at the common operating picture, the COP, to make decisions about where to apply, to move forces, conduct operations on the battlefield, et cetera, et cetera. If the information that he's looking at has actually been manipulated and it's not accurately representing what's on the battlefield, that can have tremendously bad consequences. So that's another aspect of the things you can do. And then, of course, as we've seen, just using the medium of the internet and the layer of social media on top of that, you can impact the cognitive space. I know we're competing against an information operations session here this morning, but that's a whole nother realm where the medium of cyber and cyber operations can have impact. And that isn't necessarily involving the manipulation of data or information. It's just using the systems to disseminate false information, et cetera, at a scope and scale and depth that we've not seen before because of all that this enables. So when you start talking about this and doing cross-border operations, especially when you're talking about going after information either to manipulate or change it or deny the availability of that information, or to extract that information for other purposes, for intelligence purposes, for law enforcement purposes. Those are all sort of very different, and I think have to be analyzed carefully in each of those contexts, and be very precise about the facts that you're looking at when assessing those operations. And then we can kind of obviously talk about the legal structures that surround that.
Great, thanks, Gary. That was very incredibly helpful to have us think through the different types of cross-border actions. Doug, I'm going to turn it over to you.
Thank you. So I want to talk about how we apply sovereignty as a principle in daily practice in GCHQ. And to do that and to bring all the various emanations of sovereignty together, we in GCHQ talk about cyber power and being a cyber power and applying cyber power. My boss, the head of GCHQ, Jeremy Fleming, has spoken about it publicly. It arose as a concept to help cohere the different mission sets within GCHQ, to align the intelligence mission with the effects and offensive cyber mission, together with our new responsibilities as an intelligence agency for a publicly facing service on cybersecurity. So to bring those elements together and to ensure that we were, actions we took and that the UK took in one sphere wouldn't have unintended or ideally adverse impact in another, we developed this concept of cyber power internally, and we think it applies externally beyond the UK. Of course, what you might be asking, what do I mean by cyber power? As we see it, it has three principal elements. Defence, protect the digital homeland. The National Cyber Security Centre, which is a part of GCHQ, brought pretty much all the bits of government that dealt with cybersecurity into one place, so that there's clear accountability and responsibility for doing everything from defending your defence networks and other critical national infrastructure to telling individuals in the public how to better safeguard their systems. The NCSC, part of GCHQ, responsible for all of that. And its mantra is to make the UK the safest place to live and do business online. Internally, some describe that as making sure France is a much better target for cyber attack, but there is no truth to that rumour. So defence, the first element of cyber power. Offence, the ability to project cyber power by denying, disrupting, degrading the capabilities or operations of those who would do your country harm or your citizens harm. That is a key capability that I'm going to mention a bit more later, but it's something that has to be seen in that overall context of cyber power. And absolutely critical to our concept of cyber power are the appropriate legal and ethical frameworks, which both govern what you do, how you describe what you do, and how you relate that into the wider rules-based system that we have in international affairs today. All of this is underpinned by technological capability, both as a country and as a part of government dealing with this, so you can't forget about that. And that technological capability helps provide the intelligence which flows through all of those aspects of cyber power. Without intelligence, you can't effectively exercise any aspect of that cyber power. So let me try to bring that to life a bit by talking about how we practically go about our business in exercising cyber power capabilities. And I hope from that you'll see that sovereignty is at the heart of it, both the sovereignty of the UK, the principles of sovereignty that inform many aspects of domestic law and international law. So I'll offer up 5 examples very quickly. We might be applying for a warrant to do our business. There's a publicly transparent legal framework in the UK. It was most recently reformed in 2016. And it requires that all our capabilities and all the safeguards around them to be publicly known and foreseeable in the concept of our human rights law. Human rights we apply as a matter of statutory policy, even where legally it might not, the jurisdiction of our Human Rights Act or the European Convention of Human Rights might not carry. We apply principles of privacy, for example, throughout the world in respect of any operation which we carry out. We also comply with international law at all times. That's part of the codes which both government officials and political ministers have to comply with. So we might be applying for a warrant, and the business of doing that is through our Secretary of State, usually the Foreign Secretary, and nowadays there is a double lock where a senior judge has to review and approve the decision of the minister before we can actually do conduct any of our intelligence capabilities. So that's one aspect. The second aspect I'll cover might be looking at cyber intrusions against us and being part of the attribution process. That might be for internal intelligence purposes or other public policy purposes, or it might be a more public statement, either by the UK alone or, as is increasingly common, a coalition of countries willing to call out bad behaviour online. Now, there are obviously technical and political aspects to that, but there's an important legal element too. And the rules here are those prescribed by international law. The UK doesn't agree with every aspect of the International Law Commission's draft articles on state responsibility, but it does apply many of them and uses them as a guide. So we would be looking at malign cyber activity, applying the rules of state responsibility, applying our standard of proof, which, as we've said publicly, is that to be reasonably convincing. There isn't a great deal of consensus at the international law level about what the applicable standard of proof in different cases are, but we try to be pragmatic about this. And when we go out there and talk to our partners, we try to build a common understanding of how the legal aspects of attribution are applied internally in our system, and use that to persuade other countries to come on board and call out bad behaviour where we can do so. The third element might be in applying cyber security principles to, say, the regulation of the telecommunications industry in the UK. That's an active issue at the moment. For us, we have responsibilities to provide evidence-based advice to government on cybersecurity issues, and that's what we do. The UK interests in this space are to have a strong cybersecurity element in our telecommunications industry, to build resilience in networks and increase the diversity of the market. There's some myths that are propagated in this space about certain companies, but what we try to do is bring it down on the cybersecurity aspects of that to evidence-based approach, and feed that into government, which can then apply a greater number of considerations to in terms of policy, what to do next. The fourth element I'll briefly cover is on offensive cyber. So here, we would be getting the right domestic law authorizations. We would be applying international law to that. We would be applying the approach that was set out by our then Attorney General in, I think, May 2018. Our principal thresholds there are the prohibition on non-intervention and the prohibition on the use of force. As is hopefully known by many of you, we don't subscribe to this idea that there is a specific prohibition emanating from the undoubtedly applicable principle of sovereignty. That's because of our approach to international law generally. There's the Lotus principle, and we don't see, when we apply the hard discipline of sources of international law, that such a rule existed, nor that if such a rule existed, that its content were sufficiently precise as to be capable of practical application. Now, that may change in time or with specific treaty rulemaking processes, but that's the approach that we take. In practice, whenever we conduct joint exercises or talk to partners, the application of the prohibition on non-intervention may actually reach a very similar practical outcome to that of any rule on sovereignty. So actually, some of the differences might well be quite theoretical in that space. Finally, I'll talk about the need to promote clarity and development of the rules. And there are a couple of UN processes underway. I don't think anyone expects them to go anywhere that quickly. There are voices growing for more regulation in this space, and I think they're going to be difficult to resist. As part of this process, what's really welcome is the number of countries speaking out and describing their position publicly. And while there might be some areas of disagreement between those states that have done so, what strikes me is the vast areas of commonality and the degree to which taking any of those countries' positions and applying them in practice, you'll get the same results. Now, one part of this is that cyber and espionage are absolutely intertwined, and it's hard to see a future where that's not the case. And the consequences for espionage, for people like me, are that we are going to have to come out more into the open. We're going to have to describe what we do, the rules around it, the safeguards that apply. We're going to have to do that domestically, as the UK's been doing for a number of years, and we're going to have to do that internationally, which is why I'm speaking here. Thank you.
Thank you very much, Doug. I'm going to turn it over now to Cedric, who's going to offer a perspective from the Israeli government's side.
Okay. Thank you. I'll just say the usual disclaimer that my positions are informed by my work at the Ministry of Justice, but they are made in my own personal capacity. So if I say something that sounds stupid, it's me. When we look at the Gary Corn's articles on and his position, and as well as that of the UK government on sovereignty as a principle and not a rule, and then the positions that were put out recently by France and the Netherlands, that sovereignty is a rule of international law and not just a principle, we note that these positions were expressed as part of each country's declaration or application of international law to cyber operations, which I'll define very non-legally as those types of activities that usually have a national security, national defense component, whether it's above or below the use of force threshold. But if we broaden the scope of the analysis to include fields of activity like cybercrime, civilian cybersecurity, regulatory enforcement, and fields like privacy and taxation, as well as international trade, we have a richer picture of government interests, some of which don't necessarily implicate directly cybersecurity. So I'll start with two premises. One is that we have to acknowledge that, I know it's been repeated a lot, but that a lot of private cyberspace is owned and operated by the private sector, which is under the influence of private law, domestic law, and only indirectly under international law. This is not a new phenomenon per se, but it's quite salient in cyberspace. The second thing is like the borderless nature of data, which Jen's article, Borders and Bits, which I reread recently, I think highlights this really well. And certainly from the technical standpoint and the standpoint of companies, that's the situation. So alongside the pure legal arguments of what's the proper, way of analyzing and understanding sovereignty under international law, the body of case law from Corfu Channel, Nicaragua, Lotus, etc., which were very closely associated with territory and boundaries, we face a new question, a new challenge, which is how can this territoriality of data be addressed in a way that builds upon the existing legal framework and at the same time provides a coherent and adapted way to deal with technological and social developments. So I'll give the example of cybercrime. So there the main question, which Jen has written extensively about, so I'm using some of your stuff from there. So the big question is access to data on the cloud by law enforcement, whether we're talking about directly requesting information from a foreign service provider or entering the login information of a suspect, as long as these have been lawfully obtained, entering them entirely remotely when the location of the server could be in another country. So in terms of international law, the starting point for that is the famous Lotus case from 1927 that says very clearly that a state can't take enforcement action in the territory of another state without that other state's consent. And so the question in the digital age, of course, is when law enforcement is accessing data remotely, is that enforcement inside the territory of another state? So Article 32 of the Budapest Convention is a starting point. It says that when the information is publicly available or if the user consented, then it's okay. Although the explanatory report to the convention contemplates that there may be other grounds for jurisdiction. To narrow the issue a little bit, I think it's pretty straightforward to say that if the suspect is located in the country and there's a lawfully obtained device from which the information is being accessed in the country, or if the service provider is in the country. So there's not really a difficult question of extraterritoriality. The trickier question is when law enforcement is accessing the data completely remotely, or asking the service provider in another country to provide that information without coordinating with the law enforcement authorities of the other country. And here we note opposing trends that for us on the international law side, they present a conundrum, where on one hand we see that states are exercising a lot of caution. There's currently negotiations for a protocol to the Budapest Convention where they're negotiating to address this very issue, and they're negotiating this very carefully and methodically with all sorts of restrictions. We also have the recently negotiated US-UK Cloud Act agreement, which covers the question of access to requests to foreign service providers. And over there too, it's subject to lots of limitations and restrictions and caveats. And so all this suggests that governments, they want control over what's going to happen. They're not necessarily accepting that other governments will access data without any limitations or restrictions. In the EU, from what I can see, they seem to couch this more in terms of privacy and due process, less so in terms of sovereignty as a rule, although their documents are peppered with the word sovereignty here and there, but I'm not seeing that they're really basing themselves legally on that. So on one hand, we see that states are taking a very cautious approach. They want to legislate this bilaterally or multilaterally. But at the same time, in practice, law enforcement in a lot of countries is taking a much more liberal approach. There seems to be an emerging practice among law enforcement authorities, including within the EU, to conduct these extraterritorial searches. We have a report from the Council of Europe in 2016 that attests to this emerging practice. Also a report that came out by the EU in 2018 with lots of policy options, and also refers to a survey of EU states that seem to be doing this. So when we look at the position of states and the practice of law enforcement, can we infer some kind of international law rule about whether sovereignty is a rule, how it applies to data, et cetera? And I don't think there's any certainty on this today. It's interesting to note that countries like France and the Netherlands, that in the context of cyber operations, have taken the position that sovereignty is a rule. They seem to have their law enforcement authorities seem to have a much more liberal practice. So for example, the French cyber defense document that came out not too long ago, it says that all unauthorized access to a French system could constitute a violation of sovereignty. Yet according to the 2018 EU report that I was mentioning earlier, France is among the countries that do remote searches when the server is located abroad. For us in Israel, we're considering legislative amendments to our Search and Seizure Act, including to address the issue of data on the cloud, and we're faced with a similar issue. On the one hand, the police seeks broad authority to let them do their job, investigate freely, subject, of course, to due process and privacy limitations. On the other hand, if we allow unfettered access by law enforcement to data on the cloud, well, are we concerned that other countries might be doing the same thing? And what does that mean about the privacy of our citizens? And does the answer to that question change if we're talking about, for example, serious crime? And I would note that the protocol to the Budapest Convention that's currently being negotiated, it's only going to address the issue partially because it's only applicable to the parties. And a lot of times if the data is on a server in an unknown country, you don't even know if it's a signatory, if it's a party to the convention. We have a similar issue in the field of cybersecurity. I'm referring here to, like in the civilian sphere, things like regulation, incident mitigation. So think in the US like CISA, the NIS directive in Europe, in terms of bodies like DHS, ANSI in France, the national certs. So there, the international discussion isn't as developed, as far as I can tell. It's not as developed as it is with respect to LOAC, cyber operations, cybercrime, and there isn't, as far as I know, like a common international law vocabulary or taxonomy to frame the questions of extraterritorial jurisdiction and sovereignty. And yet, given the fact that the private sector is very much in that space, the challenge is not any less pressing. So think, for example, of a critical infrastructure company that has its information on the cloud. So what would be the international legal framework applicable to the CERT if it were to want to do incident mitigation? Where the state where the cloud servers are located raise any kinds of similar concerns as those that we see in the cybercrime discussion. So I don't know the answers to these questions, but I think it shows that the equity, the sovereign interests, they haven't been fully fleshed out yet in this field. In the field of regulatory enforcement, so think, for example, countries' tax authority, anti-money laundering authority, privacy protection authority, and others, they all need to investigate activity online, and yet the data will not always be publicly available. So think, for example, of a case where the tax authority, for example, has lawfully obtained the email address and password of a senior official in a company that they're investigating. So are they preempted from entering that information, sorry, simply because of an international law question? What kind of due process requirements do we expect from the other country? Do we want to be notified before or after the fact? So these are the questions that we're dealing with. We don't yet have all the answers. In the field of international trade and IP theft, it's pointing in a different direction. So presumably there, if it were said that sovereignty is a rule and not just a principle, that would enable the affected country to take lawful countermeasures against the infringing state. So overall, if we look at the interests at play and the challenges that are faced by different government authorities, and also the practice of states, they all point to different directions in terms of qualifying sovereignty and saying how it applies to data. And I think this highlights that state practice and opinion jurists are still developing. We're not yet able to point to a clear rule of customary law, and we're going to need more state practice and opinion jurists to get to that point. So where do we go from here? I'm going to conclude. I'll emphasize that these are my own personal speculations, not the position of the Israeli government. So one is that I think we have to acknowledge that even if we come up with like a unified theory of sovereignty as it applies to data, whether as a rule or as a principle, we're going to need a nuanced application of that is sufficiently context specific and at the same time coherent with the big picture. So we might think, for example, whether we say that sovereignty is a rule or a principle, we might think of like an ascending scale of sovereignty interests, where we say that the closer we get to national security, the more a state needs to be able to act freely, the same way that it does in the non-cyber world when it feels that it's under threat. And the closer we get to enforcement involving specific individuals that don't involve a national security component, we might want to restrict what another state can do to investigate that individual. And along the spectrum, we might say that cybersecurity is closer to national security. Cybercrime is maybe one step removed, unless we're dealing with things like terrorism that obviously involves national security, and purely regulatory administrative enforcement action against specific individuals and companies is further away. So that's just one way to map the issue. There are conceivably others. We should also be mindful of the broader internet governance impact. Like, what do we want our internet to look like in 5, 10, 20 years? How do the elements of the private-public interface play out in developing the rules? There's an increasing push within developing countries and more recently within the EU to assert and affirm their data sovereignty, which is often associated with data localization, which in turn has international trade implications. The Budapest Convention highlighted the divide between countries with Russia and China promoting their own views of what cybercrime is and what sovereignty means to them. And I think the approach that the international community will take with respect to the applicable legal framework will also influence the future of the internet as it currently is. And lastly, international law, I think, is in a state of flux. We're not necessarily going to find the answers in like a pure application of existing law. It's not just about the lex lata, applying the law dryly. For international law to evolve, it has to be responsive to new challenges and not just in the field of cyber operations. So clearly, we don't want to be throwing away decades of international jurisprudence just because there's this thing called data in cyberspace. So from Lotus, Corfu Channel, Nicaragua, all these cases, these decisions should, of course, inform how we frame the debate, but at the same time, we shouldn't be wary of incremental change.
Great, thank you. Thanks for laying out in incredible detail all the complexity and highlighting why we really should have 5 days for this instead of an hour and a half. There's obviously a lot of intersecting issues to dissect here. I'm going to turn it over to Chantal.
Thank you. If I might echo the disclaimer that this is my thoughts and does not represent the views of the Australian government. I thought I might take you through Australia's practice and some of our statements to draw out whether Australia may or may not, where it may or may not sit on that continuum of sovereignty, and whether it's a rule or whether it's a principle that simply gives colour to international law. Now, in 2017, Australia issued, as part of its international cyber engagement strategy, a statement on the application of international law to cyberspace. Now, that statement recognised that the principles on state responsibility, as mostly reflected in the articles on state responsibility, apply in cyberspace and give rise to a due diligence requirement to the extent that if a state is aware of an internationally wrongful act and has the ability to put an end to that harmful activity, it should take reasonable steps to do so, consistent with international law. It also acknowledged that sovereignty applies. Now, in 2019, Australia issued a further statement in which it noted that the principles of non-intervention and the prohibition on intervention in the internal or external affairs of a state also applies in cyberspace. It also recognised, importantly from Australia's point of view, the application of international human rights law to activities in cyberspace and the obligations of states to protect the rights of individuals in their jurisdiction. And this includes privacy. And this obligation to protect privacy underlies a lot of Australia's practice. Now, you might note that neither of those statements made clear whether Australia does or does not think sovereignty is a rule in itself, a breach of which may rise to a breach of international law. Now, against this backdrop, we have, in between 2017 and 2019, a flurry of domestic legislation relating to these activities. Now, from an intelligence perspective or a foreign interference and espionage perspective, Australia issued a range of laws criminalising foreign interference in Australia, requiring foreign actors to register, so similar to the US FARA Act, requiring them to register and creating offences if you don't register and make it publicly known that you are acting on behalf of a foreign actor. And also increased and amended Australia's espionage laws, although, again, with that respect for human rights, creating a defence for journalists where their disclosures are in the public interest. Now, that was also underpinned by Australia implementing a counter-foreign interference strategy. In that strategy, it outlines that foreign influence is characterised as an activity that is open so that you know who the foreign actor is and who they are seeking to influence. Interference, on the other hand, is characterised as an activity that is covert, coercive, deceptive, clandestine, and undertaken on the behalf of a foreign power. Now, you'll notice in that definition of interference that it spans activities that may be a breach of sovereignty all the way through to coercive activities that would be a breach on the principle of non-intervention. However, that's from a policy perspective. So again, it doesn't quite answer the question of where Australia sits on that spectrum of whether sovereignty is a principle or a rule. In contrast to all that legislation criminalising intelligence activities and foreign interference is our founding legislation for our intelligence and our foreign intelligence agencies, which gives those agencies the statutory functions and obligations to conduct similar activities overseas. So for me, that suggests that where Australian practice and policy sits is that access to data overseas for national security and intelligence purposes remains as it always was, and that in that states practice espionage, and that includes entering into other countries, and therefore access to data overseas continues to be not contrary to international law, even if that means you may have a persistent presence in another country's systems or systems in another country. From a law enforcement perspective, it's slightly different. For law enforcement, we have our traditional frameworks of mutual legal assistance with a range of countries. And we've reflected that to enable greater access to data overseas through a new act in 2018 called the Assistance and Access Act. It has a much longer title, but briefly the Assistance and Access Act, that requires or enables our federal law enforcement agency, the Australian Federal Police, to seek a warrant where requested on behalf of another country to access data in a computer system on their behalf and undertake that activities and obtain that information or evidence for that foreign partner. Now, the explanatory memorandum to that legislation, and indeed the provisions of the Act in which it's been included, the Surveillance Devices Act, specifically require the consent of another country if our federal law enforcement agency is to use a computer access warrant to obtain data on a network, on a computer network. If that data is stored overseas, it requires our federal police to obtain the consent of the country in which that data is stored. That might suggest to you that we take a very hard view of law enforcement activities and sovereignty and territorial responsibility. However, there is wiggle room in the legislation and in the explanatory memorandum to it, where the law enforcement agency is not required to obtain consent, where it's not reasonable or reasonably practical, or it's unknown where that data is located. So if they do, in that example given by Cedric, access data from a computer or computer network in Australia, and they're unable to determine the location of that data, then they may access that lawfully under our domestic laws without having to get any foreign nation's consent. So the other aspect I think I'd like to draw out is that that's in terms of a law enforcement activity, so the investigation and prosecution of cybercrime. Australia then creates a distinction between the investigation and prosecution of cybercrime and the prevention and disruption of cybercrime, and places the prevention and disruption of cybercrime into the national security basket, and has given statutory functions to one of our intelligence agencies to prevent and disrupt cybercrime by persons and organisations outside Australia. Again, the explanatory memorandums talk about our international human rights obligations to protect privacy. They don't talk about other international law or principles to do with sovereignty. So from that, I personally take away that Australia sees sovereignty more as a principle rather than a rule of international law, that the breach of which does not amount to a breach of international law.
Thank you. I'm going to turn it over to you to take it away.
Okay, so I
Answer
get to
all
play
unresolved
clean up
questions,
here.
yes.
So I'm going to do my best. I think a few things come out here, which is these concepts that we're talking about, data, cyber, sovereignty, each one of these concepts is very imprecise and is used by many different people to mean many different things. And in fact, we're talking about probably 50 different kinds of problems here. And I think what we're getting to the point in the conversation about these issues that it's going to be very hard to make any serious progress until we figure out which of those 50 problems we're talking about. Right, so are we talking about the problem of states pre-positioning malware on the electrical grid? That's one set of problems. Or are we talking about states sucking up a huge amount of data that sort of in this short term doesn't seem to have obvious national security implications, but if you aggregate all that data over some time, it actually could have very serious national security implications because it gives a lot of visibility for a nation state actor into all of you and us. And what we're up to. So these are all very different, and then the criminal enforcement questions, privacy questions, these are all very different sets of questions. So I wanted to just start by saying that while this conversation I think is incredibly helpful in kind of laying out the kind of framework and sort of charting a set of the kind of outer bounds of the sets of questions and problems we're dealing with, that going forward, we're going to have to start figuring out which of these problems we're trying to make progress on and really focus on those, because we're not going to have a blanket rule that's going to solve all of these problems. That's the first thing. The second thing I want to say is that part of the difficulty in this space is that we are taking existing rules and trying to figure out how they apply to cyber, to sovereignty, to data, in part because states have been very slow to act collectively to try and fill in these gaps. So there have been some conversations at the UN GGE conversations, which got far enough to say that, yes, international law does apply in cyberspace. So that seems like not a big deal, but that seemed like that was a big accomplishment to kind of get agreement on that. In fact, apparently there's been actually a little bit of backtracking by some of those who participated in that determination in 2015. The most recent rounds of talks didn't result in any consensus document because they couldn't agree. There's a new round of conversations. The UN GGE has a new round, which is US-led, which is a sort of more limited set of states that are trying to talk through what are the rules that are going to apply in this space. Then there's a Russian-sponsored separate conversation of all member states in the UN called the Open-Ended Working Group, which is working at the same time on the same issues and is supposed to also make some progress in the space. But Gary and I were on a panel with the gentleman who's leading that, and I think it's maybe fair to say that he was not terribly optimistic that they were going to make significant concrete progress on that in the limited amount of time that they had to work on this. And so what that means is that we don't have cyber-specific rules that are being issued by states, which ordinarily are the actors in international law who are giving us the rules that we can live by. And so what we're left trying to do is individual states are articulating their own views to try and generate an opinio juris in this area. Now they're in the process of articulating inconsistent views about these questions. So you've got the Dutch on the one hand saying, yes, sovereignty is a rule, and if you violate sovereignty, we can hack back. That gives us a right under countermeasures to respond. French seem to be on board with that view as well. Maybe a few other countries share that view. The UK, the US, Australia, a number of other states saying, wait a minute, that's a much too aggressive rule, because if sovereignty itself is a rule, first of all, what the heck is sovereignty? Like I've actually studied this for 15 years and I couldn't tell you. It's a very amorphous concept. So to call it a rule that can be violated, that then gives you a right to respond with countermeasures is actually a pretty dangerous thing. And I think that's the US, UK, Australian view, that that's much too open-ended, much too likely to lead to a set of very aggressive actions in cyberspace. But all of that is happening precisely because the states are not acting to fill this space. They're not acting collectively to fill this space. And so we're left both trying to figure out how the rules as they exist might apply, rules that were not written with cyber in mind. So in the use of force context, for instance, which is one of many of these areas that's relevant for cyber, the key rule is the UN Charter provision, Article 2.4, which prohibits the use or threat of force against states, against the territorial integrity or political independence of the state. What's territorial integrity or political independence of the state in cyberspace? It was written in 1945. Nobody was thinking about cyberspace then. Now, we've all begun to develop some views about what we think the right way is to think about that in cyberspace. And I actually think there's a fair bit of collective, over now about a decade, collective views about when something constitutes a violation of 2.4 in cyberspace. And the short answer is it doesn't happen very often, thank goodness. the only action maybe that most of us know about that likely as a standalone operation violated 2.4 might be the Stuxnet attack, although there's some disagreements about whether in fact that qualifies or not. But most of the rest of cyber activity falls below that threshold. So this is the so-called below the threshold problem. And that's where the problem really comes in. So we really don't have agreement at all as to how to regulate that space. And that's where the scramble is happening. Now, why are states having such a hard time getting together to resolve these questions? I mean, part of it is, like, it feels like it's been a long time to us, but international law does tend to move slowly. So, maybe we shouldn't be so surprised that these problems haven't been fully solved just yet. So maybe part of it is we ought to be a little bit patient. But I actually think that part of it is also, Doug, I hope it's not unfair to call you out here, but your opening comment I thought was incredibly revealing and interesting here. You said we spy and we hack and we just try to stop others from doing the same to us. There's a lot of that. The actors in this space spy and hack and try to stop others from doing the same to us. And because we're on both sides of that line, most of the actors on both sides of that line, they're a little bit ambivalent about how they want to articulate what the legal rules are. On the one hand, they want to regulate what others can do to them. On the other hand, they don't want to embrace regulations that are going to prevent them from doing the things that they want to be able to do. And I think that ambivalence is part of what's playing out in the lack of resolution at the state level, collective state level, about what the rules are that they're going to accept as regulating state behavior. And until we can get past that, I think we're going to continue to be in this space where states are not going to collectively answer these questions for us, and we're going to be stuck trying to figure out on a kind of individual basis kind of how the law as it exists regulates this space. But I think we're only going to make progress on that set of questions if we don't try to think about the whole problem all at once, but if we try to think about individual sets of problems much more specifically, much more fine-grained, and figure out how the rules apply in those particular contexts. And that's where I think we're likely to be able to begin to make some progress.
So thank you. I fully agree with everything you just said. And so I'm going to pick up where you left off and turn back to Gary for a moment. So the provocation was basically that states are both taking advantage of the gray areas and also both doing things that they don't want others to do to themselves. And that doesn't seem like it's a problem that's going to go away. And so if that's the case, what is the realistic and appropriate role for international law going forward in this space? Are we always going to operate in a realm of ambiguity? That's question one. And then question two is, going back to your initial discussion of the problem, you laid out three prongs. You laid out measures that deal with functionality of systems. You laid out measures that deal with efforts to manipulate data. And within that, we heard from the various presenters various different types of manipulation. There's manipulation for law enforcement purposes. There's manipulation for intelligence gathering purposes. And then there's manipulation that not just is accessing the data, but actually changing the data, as you talked about, to changing the information that somebody is receiving. And then you also talked about a third category of reaching out for deceptive purposes, for propaganda purposes. Again, following up on what Ona just said about the need to be specific, I want to talk a little bit about that second category and the question as to whether or not, and this has come up with some of the other panelists, whether or not the purpose by which the state is acting matters. Should we be thinking just about effect, or should we be thinking about purpose as well?
Yeah, just out of curiosity, how many people in the room have been involved in negotiations at some point in your career? A fair number. First rule of negotiation, don't negotiate against yourself, right? So I understand the frustration at times. It caught me, the states have been slow to act. I think that's accurate as a matter of fact, but it seems to presume that states have to be moving faster. States make that decision. And it's part of the negotiation process. International law is a negotiation process that states make international law ultimately, and I think doing so, it's very important. It has a tempering effect. It does have a very important normative role to play, but it's also not a panacea. And there are cross-cutting interests. And so as you are looking into the ways that the medium of cyber capabilities as a means and method of statecraft is developing, it doesn't surprise me that states are cautious in that negotiation process overall. I also think we've seen there's lots of sort of raw areas here and challenging areas. Fascinating in this discussion, I don't know that anybody brought it up, but not long after France issued its statement, which I'll speak to in a second, but there were reports that France conducted a mass botnet takedown of about 850,000 nodes across the internet. Most of the countries it's reported where those nodes resided were in Latin America. I don't know specifically. I don't imagine that France went out and sought consent. Now, this was a law enforcement operation. Whether the purpose there, they considered that somewhat different. And nor do I know the technical means by which they sort of neutered this cryptocurrency mining botnet, but they swapped out a server in France, a control server, that when those nodes called into that C2, that command and control server, it was now sending out injects to somehow neuter the malware that were on all these different devices and nodes. That seems to me very, very hard to square with what some assert was an emphatic statement of endorsing sovereignty as a rule. Now, as to that, I think the Netherlands was very clear in their view on that point, although the Netherlands then turned, one, and never mentioned the question of espionage, and two, said the question of cross-border law enforcement is an open-ended question, which seems somewhat internally inconsistent. And France, I personally, in reviewing that document, never saw where France completely squared the circle and said that what they said is certain activities on generating effects on infrastructure inside of France may constitute a violation of sovereignty, but they never used the clear language, which, like disagree or agree, was very clear in the UK Attorney General's statement, that it constitutes a breach of an international obligation. And in the discussion of the availability of countermeasures, they never tied countermeasures strictly to any breach of sovereignty. Right? I think it was a very pragmatic document, but it left a lot of room in there as well. So, and then you see the action. I think also too, in terms of precision and things, framing of the question really matters, and framing of it with an understanding of how international law works. So we've talked about this sovereignty applied to data. I'm not sure I fully understand the framing of that question. What is the relationship that a state has to certain types of data? And then that drives what the law says about how states can interact with each other, right? So there's sovereign interest that you may establish a connection, an interest, national security otherwise, with a set of data, either national data developed or the data of your citizenry, right? But then international law speaks to how states interact, and how does that now come into play and implicate what another state may be doing to the data that the victim state sort of has a relationship to. Or the question, the sort of more unique area of international law that governs how states interact with individuals. That's either in an armed conflict setting, where we have a specific set of rules in the law of armed conflict, or human rights law. And so there are implications of a state interacting with data that have human rights implications, but that's very complex. And we get into all kinds of questions of extraterritoriality of human rights law, et cetera, et cetera. So I think part of it is just sort of a framing of the questions. Like I often hear, does international law apply to cyberspace? The answer is no. It applies to what states do in and through cyberspace. International law applies to states and what states do. So the framing of the question often, I think, can take you off in tangents. Does the purpose matter? I think it very much can matter, because within the frameworks of the rules that states have agreed to and consented to prescribe their activity, context matters, and I think purpose does matter. So law enforcement versus espionage. Yeah, there are some distinctions there. But I thought your analysis was fascinating and spot on. A lot of the, I don't speak for Australia, obviously, but passing laws that criminalize interference, I think that's fascinating. This is a problem area that we need to get after, but that's a domestic law question. It's an exercise of domestic jurisdiction and internal sovereign prerogative that is an expression of a sort of a collective policy view of the state of Australia. It's not, unless there's some statement otherwise saying that we are doing this because we feel obligated to as a matter of international law, right? So those are two different sets of circumstances. But yeah, I mean, I think the purpose can matter because those contexts can vary. How international law has evolved, for example, to regulate how states interact with each other in the domain of the maritime domain and in naval and high seas operations and the law of the sea, that context and purpose matters. So I think you have to kind of peel that back in any given situation.
So Doug, I'm going to give you a chance to weigh in on anything you want to address, but also interested in one of your comments about your sense that you made the point that you thought some of this debate was more theoretical than actually practical, in the sense that as you've been working with partners and your position is that of course there's a prohibition on non-intervention, that there ends up being some sort of coalescing around what the right approach is, regardless of where one starts. So I was wondering if you could talk a little bit more about that as well.
Okay, thank you. Where to start, really? So, I mean, one thing I think is worth noting, and just to refer back to Una's comment, which I don't mind at all, is we have to recognise that there's a host of activity that any state with the capability and resource to do is by and large doing, and it's not talked about. And so when I'm talking about spying, this is an activity that has at least a provenance going back to the Bible or the Taruk. Moses sending agents to recce the land of Canaan for a potential settlement. The idea that spying is somehow unlawful or inimical to the interests of a rules-based international order, bearing in mind I am a spy and representing that organisation here, I just don't think cuts the mustard in the world that we live in and have lived in for centuries. What's different nowadays is we have to talk about it a bit more, because most countries have or are developing or thinking about a much more accessible and transparent domestic legal framework for what they do, particularly when it comes to cyber activities, because not everyone is involved with hostile agents of hostile state actors or terrorist organizations or serious organized criminals, but everyone uses the internet pretty much. And so you have to give people a sense of what your capabilities are and what the safeguards are. And in the UK and across Europe, Council of Europe countries that have signed the European Convention, that is the law as well. That our requirement of Article 8 and the right to privacy is that the legal framework around it be foreseeable. So when it comes to the international law framework around that, I completely agree that there are grey areas and ambiguities, but that's the nature of international law. The fundamental, kind of the most important, the sexiest rules of international law around the jus ad bellum contain a host of ambiguities, both in terms of how countries apply the law, what they think the law is, and then the factual examples that are used to demonstrate one position or another. So the kind of absolute fundamentals of international law contain grey areas, and so we shouldn't shy away from that in the cyber world. But to address your question, I mean, I do, when I talk to others, and we talk about specific examples of where, bringing it back to Gary's point, of a breach of an actual international obligation that is applicable, there's a remarkable degree of commonality. You know, when you're talking actual practical examples, most intelligence services that I would talk to would agree a specific example would fall in the line of an unfriendly act, one that would have political or diplomatic consequences, but not something that you could seek international legal redress for. And there are examples on the other side of the line, and one of the things we've been trying to do in the UK, and it's not just a GCHQ thing, it's a cross-government thing, is speak up about those practical examples. And the Attorney General's speech gave a few around democracy, around medical services, around financial stability. And I'm sure that, you know, the fact that that I'm mentioning that as a thing worthy of note indicates the immaturity of the debate so far. But so what I'd really hope for is a situation where my counterparts in many countries both speak out a bit more publicly, but crucially talk to their foreign services, talk to their ministries of justice, you know, make it well understood what they're actually doing and what the framework they're applying. Because too often I see, you know, Gary's practical example is well made, a situation where, you know, I'm talking to my counterparts and they're telling me one thing, and what's being said publicly or what's being said by diplomats in a UN forum is very different. So they've got to connect the dots. And I'm not saying we've got it made or we're doing everything that could and should be done, but we're at least trying to present a joined up approach as the UK. And in doing so, we're also very willing to listen and to learn from the experience of others. The way that the particular position around sovereignty was formulated in the Attorney General's speech was really deliberate. You know, we're not saying we're saying this is not a current rule of international law, and you might want to underline that word current, because if state practice and opinio juris and the sources of international law applied in a rigorous way led to a situation where we actually understood more countries talking about a rule of international sovereignty in cyberspace, and we understood what the content of that was. You know, maybe there can be a situation where we have a rulemaking moment. You know, the traditional one is a treaty, because there's a democratic element to that, at least for those countries that are democracies in the ratification process. But you know, we're quite a way off that at the moment. So for me, we've got to live with the ambiguities that we have now. I really want to see more people out there talking, even if, you know, they don't necessarily reflect my position. And fora like this are a really valuable means of doing so. So I would hope that you would have even more international panels of this nature in future events.
Thank you. Do you want to do?
I agree with, you know, pretty much everything what's been said so far. Maybe just one point to add. Gary was mentioning how data means a lot of things. I think it's the same thing with sovereignty. The word sovereignty gets thrown around a lot, and it means different things to different people. I've heard the expression sovereignty over data. I'm not sure what exactly that means. In the past, sovereignty was so closely associated with territory and borders that we understood it in a certain sense, and now we're being really challenged to ask what exactly it means. I remember in the Talon manual where they talk about sovereignty that sovereignty applies to people and activities and protocols and a logical layer, and I have a hard time with that, imagining what sovereignty over the logical layer means exactly. So I really agree with Gary's point that it's going to take a long time. Like if we think of just the law of armed conflict that evolved over decades upon decades to get to the point where we are today, where it's a lot more granular. So we kind of expect already today an answer to the question, but I agree with Gary. It's going to take time, and that's okay. And states will negotiate this carefully along the way through their state practice and you know, the text that they negotiate in different areas of law, as Una mentioned also.
So Chantal, I'm gonna take the provocation that we go deep on some issues and ask you to talk a little bit about the Australian Assistance Act, and you mentioned this previously, the requirement of consent anytime law enforcement is knowingly accessing data outside of the country. And wondering if you could talk a little bit more about the origins of that and how it relates to the international law question.
Absolutely. So we have mutual legal assistance agreements with a large number of countries. And so when the government moved to introduce the Assistance and Access Act, it considered, it approached it on a similar basis, but the reasons articulated for that consent were premised on the basis of accountability and due process and the protection of privacy rather than any overwhelming international law requirement. And that's really interesting when you compare it to Australia's amendment to our war crimes legislation in 2016, where we amended our domestic legislation to clearly enable the targeting of members of our organised armed groups. That legislation went through with a very strong statement on Australia's position that that was lawful under international law. So I think there's quite a difference there in terms of how Australia's viewing its obligations. If I can, I'd just like to touch on the problems with developing opinio juris and understanding state practice. For me, when I think about characterizations of cyber activities, it seems very similar to attribution. There are different types of attribution: technical, legal, policy or political attribution. Each reflects different standards and different interests, and that applies to characterising activities in cyberspace as well, in that, as with the example of Stuxnet, some people say it was a use of force, some people say it was below a use of force, but a state may have a vested interest in how that activity, either conducted by them or perpetrated against them, is characterised. They may not want to have it characterised as a use of force for several reasons. It might be that they don't want to be seen as weak if they're not in a position to respond. They may not want to be seen as escalating something when the premise under international law is that you don't escalate. So states need, as a matter of practical reality, some grey space in which to operate so that you have both the intersection of law so that their actions are lawful, but it still leaves as much policy remit for a practical response to occur that meets all the different interests. So I'm not sure that we will necessarily develop any concrete practice rapidly in this area.
I'm going to turn it back to you and ask a question and allow you to respond, and then we're going to open it up for questions. But one of the things, as listening to this conversation, that I personally struggle with is I fully agree that solving any one of these problems requires a deep dive into any particular issue. But there's also a real value in kind of stepping back and thinking about the broader themes and implications and general principles. And so, I'm asking genuinely because I constantly am struggling with this question as to what's the appropriate entry point into any one of these issues. And I think it depends a lot on what one's trying to achieve, but I see value in both.
Yeah, I would say that that's right. So, I mean, on the one hand, it's useful to step back and try to think globally about the set of problems that we're dealing with and notice the connections among them. Because when you do that, you might see that if you're particularly, for instance, if you're looking at a set of problems through a use of force lens, you might, if you step back, realize that actually you have a whole set of tools through criminal law that might actually be better adapted to dealing with the set of problems that you're concerned with and that may not actually be appropriately dealt with through the use of force lens. And if you're just stuck in one silo, you may not see the ways in which there are lots of different ways to deal with a set of problems. I also think that there are shared problems across these areas that I don't want to deny by any means. The fact that the internet is developing so rapidly, the fact that data is not really in any single place. It's generally in lots of places all at the same time. With packet switching, even a single email message is divided up into lots of different pieces and sent many places around the world before it goes when it's coming from one computer to another computer, you know, it probably transits many, many countries in between. And that data also is mirrored in lots of different places. So, you know, when you're watching a Netflix movie, that movie is on a server that's relatively close to where you are, and that same Netflix has those servers that mirror all of that same data in lots of different places. So where is that data? Well, it's kind of in lots of places, it's not in one place. And so I think we do need to think about those sets of problems across these different areas. So I think you're right about that, and recognize that there's some common challenges that we face. But then when we're trying to think about how we're going to solve these problems as a legal matter, I do think that's where we need to kind of begin to drill down, because we're not going to have a one-size-fits-all legal solution to these problems. We're going to have a lot of different kinds of solutions to a lot of different kinds of problems.
So I want to open it up to questions. We have about 10 minutes, so I ask that you ask a question, and we will move on. Eric.
I got a question which is kind of like a hot topic right now, supply chain security, and trying to bring the international aspect to that. It seems to be that there are global supply chains, and some of those are being kind of poisoned deliberately or just negligence by some actors who find them useful for their dual use. So my question for you would be that do you see a way forward on the international treaties and so forth to set rules of engagement in this new era, or do you think the current methods apply, or there is only option is actually just separation and working only with your close partners? Thank you.
We'll take a few, why don't we take 3 questions, and we'll let the panelists answer,
okay.
and then thank you.
So my question is about data. Gary, you started out by saying all data is not the same. I think the Talon Manual treats all data the same, and maybe incorrectly, but I'd be interested in what you all thought were the differentiating characteristics of data. What would you, if you're saying data is not all the same, how would you divide it up, and what importance would you lay to different categories of data?
One more.
I'm Colonel Almena from Brazilian Cyber Defense Command. My question is, do you perceive a movement towards internet castles, like we see the Great Wall in China and Russia saying they will close their internet? Is the world moving towards this direction?
And why don't we take one more, and then I'll give the panelists each a chance to answer.
My name is Marcelo. I'm from the Brazilian Army War College. I'm a PhD researcher there. Well, my perception may be naive, but I think that the rule of law would apply to defend the weak against the stronger, because, well, the stronger defend themselves. So, in this case, since my country doesn't have the ability, the technology to hack back when attacked, and we have been hacked by Russia, the Chinese, NSA, just HQ, and so on. What should we do in this case to defend ourselves, since the international law is going to take a while to be established, to be consolidated? What should we do in this case? Should we start hacking back? This is my question.
All right, so I'm going to go down the line and let the panelists answer the pieces that they...
I mean, for me, I just picked up something Una said about solving the problems, and I think obviously international law and international cyber law is there to help try and solve problems in the instant, but it's also there to provide a framework for behaviour and activity. You know, the ideal would be that we got to a place where cybersecurity was so good and everyone was following the rules so much that none of the hacking was ever needed by states. That would be the ideal utopian sort of place that we would all, I imagine, aspire towards, even if a more realistic world of realistic view of the world suggests it's some distance off, if ever achievable. So for me, it's what we're trying to do by talking about international law, by applying it and developing it, is to get that framework for what's acceptable and what's not. I think spying has wheeled the oils of international relations for, as I said, for centuries, and has a value in helping countries properly understand each other, de-escalate conflicts. But what's less acceptable, at least to me, is indiscriminate attacks on civilians, the large-scale theft of intellectual property, hacking of commercially sensitive information, and just sort of indiscriminate hacking against institutions or processes like elections, democracy. You know, what do certain countries doing this sort of thing hope to achieve by that? And I come back to the point that this is not something that certainly the UK is looking to do when it's talking about offensive cyber. We're talking about very limited, proportionate responses to what's going on against us. We're not talking about some kind of lawless cyber world where everyone's trying to disrupt each other, and you know the cyber weak are at the mercy of the cyber capable. That's not what we're after at all. What we want is a world where cybersecurity is a lot better, and where the conduct of international relations can be carried out with a degree of stability, with a degree of deterrence, and with international law helping to do what it does best, provide a framework for what's acceptable and the resolution of disputes.
Okay, so there's a lot there. Let's see. Eric, I don't know that I can give you a full taxonomy sitting here, but I think that there's data that has different value interests attached. An individual, there's privacy interests that are greater in certain types of data than others. The data that resides on a SCADA control system doesn't really implicate privacy questions the way that your intellectual property might. And so I think the law addresses those interests differently generally. And so I think that has to sort of feed into, we have to be more nuanced in thinking through that when we're talking about how a state interacts with data and what interests a state has to assert in protecting data in that regard. The supply chain question is extremely important and hard. I think by and large that's going to be something that's addressed by individual states in a domestic framework, and in a globalized economy and commercial markets, states have to make some decisions, and we see this playing out currently in what types of products and things you're going to allow to come into your infrastructure. I think it's going to be harder to get some sort of international regulation of supply chain operations more broadly. And to meus amigos brasileiros, I'm not sure if I remember both questions, but listen, I think that each state has to make sovereign decisions about how to prioritize resources and how to implement protections, understanding that I think all states are engaged in this game to some varying degree. And I think that kind of what Doug alluded to, some level of operations, obviously, the better you can secure your own infrastructure and networks and make it harder for anyone to penetrate, access, and do harm, that's a positive, and sort of rise all boats there. But that's never going to solve, even for the most sophisticated countries. They're getting hacked, okay? And so, I think there is some element of proportionate counter-cyber operations and strategy that have to be, each state has to look at and think about in order to better defend itself and protect itself from these problems.
Yeah. So I think absolutely in response to the question of can we set rules, absolutely. Yeah, we can, and we do, as states have a vested interest in establishing norms and norms in cyberspace. It might take us a while to get there though. And that's part of the process to defending the weak against the strong, noting that as a middle power, Australia is both strong and weak. And so we have a vested interest in ensuring that norms are established for cyberspace. The cyber engagement strategy that I noted before also has a set of norms in one of the annexes that Australia holds to. And in respect to different categories of data, definitely. So not only are there different technical types of data, but again, data has different value for different countries. And as I noted previously, privacy in respect of personal information is definitely high on the list. And including, because of our separation of private, public, the protection of private information is also something that gets greater weight.
Well, I'm tempted to try to go after all of these questions, but I won't, given that we're nearly out of time. I think the main thing I would say is that conversations like this are key to beginning to fill in these gaps, and that this is an area where sometimes people have a tendency to kind of throw up their hands and give up because it's very complicated. I think it's precisely because, in the modern era, the key is going to be to figure out how do we fill in these spaces with law, and how do we better regulate or create a framework within which states can properly act so that states don't have to ask this question, should we be hacking back? And private companies don't have to be asking that question, should we be hacking back? Because I hear that at these conferences that I run where states say, well, where private companies say, well, if the state's not going to be able to protect me, maybe we should protect ourselves. And that's a very dangerous road for us all to go down in a world where these tools are becoming more and more powerful and capable of leading to a lot more damage. So I think it's in everyone's best interest to continue these kinds of conversations and begin to try and continue to fill in this space so that we have a better sense of what the rules of the road are, even if we are still a little ways away from states agreeing collectively to a set of kind of clear, capacious rules that govern all the different kinds of questions that we've been discussing today.
Fine, I'll answer the question about internet governance and balkanization because it wasn't addressed, I think. Your guess is as good as mine. If we look at the way things are going right now, it seems to be going into further fragmentation. And then just last thing is, if you heard a couple of days ago, the news came out that the UN approved work on a new cybercrime treaty. That was the proposal of Russia. So with everything that means.
So, please join me in.
Taking the panel
Yes.
out of the taking a 30-minute coffee break.
Thank you.
So thank you.
Thank you very much.